Justices of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to be before they draw near, give their attendance, and they shall be heard.
Great. Good morning. Please have a seat. Good morning. Welcome to the Appellate Division 4th Department. Just a few reminders. First and foremost, the judges have made a real effort to study the briefs and the portions of the records that are salient to the case. So there's no need when you come up here as counsel to tell us the issues or tell us the facts. Get right into your argument if you would, please. And we would also ask that to the extent that you can, in fairness to your clients, please focus on the contentions that are most important in your briefs so we can pay attention to what you think is most important. Also, don't forget we do not allow rebuttal. So we have the appellate go first, respondent, that's it. If there's a unique situation where you thought you needed to do a post-argument submission, you may apply for that and submit it after the fact. We're not encouraging that, but in case you need to do it, that's fine. So with that, the first case for argument today is number 778 and number 779, People versus Coleman. And you're Mr. Cooper.
I am, Your Honor.
Welcome to Rochester.
It's good to be here.
Go right ahead.
Thank you. Good morning, Your Honor. May it please the court. Matthew Cooper on behalf of the appellant, Demetrius Coleman. Mr. Coleman appeals from his convictions, as well as from Supreme Court's denial of Mr. Coleman's motion to vacate his convictions. This court should reverse the lower court's denial of Mr. Coleman's motion to suppress because Sergeant Kaiser improperly escalated the traffic stop and because Mr. Coleman did not provide voluntary consent to search the rental car. In the alternative, this court should vacate Mr. Coleman's convictions because Mr. Coleman did not voluntarily waive his right to a trial by jury, because trial counsel failed to provide meaningful representation throughout the course of the proceedings, and because Mr. Coleman was denied his right to be present at a material stage of the proceedings. When Mr. Coleman was pulled over by Sergeant Kaiser after allegedly running a red light, Mr. Coleman was cooperative from the outset. Sergeant Kaiser approached the passenger side of the rental car, and Mr. Coleman immediately informed him what he was doing.
Mr. Cooper, we're familiar with the facts, and I can guarantee you that every member of this panel has watched that video at least once. So with that, please take us to the most salient facts that you think support your contention that suppression should have been granted.
Your Honor, suppression should be granted because Sergeant Kaiser improperly escalated the traffic stop. When Mr. Coleman was being patted down with his hands on top of the rental car, Sergeant Kaiser asked him, without the requisite founded suspicion of criminality, "Nothing in the car you shouldn't have?" This question gets to the inherent criminality of the circumstances present and must be justified by a founded suspicion of criminality. Sergeant Kaiser also escalated the traffic stop to the left.
If the officer had acted at that moment, we'd have an issue, but he didn't act at that moment. Instead, he brought your client back to the police vehicle, correct?
He did bring Mr. Coleman back to the patrol car.
So that first question arguably is irrelevant?
It is only, I wouldn't say irrelevant, Your Honor, but the circumstances demonstrate that it was not sufficiently attenuated from the illegal action of improper escalation to the ultimate warrantless search.
And when you say illegal action in that context, you're referring to your unpreserved argument about coercion?
Your Honor, the argument regarding whether or not consent was voluntarily given is preserved. And yes, the time between when Sergeant Kaiser initially escalated by asking about the contents of the vehicle was not sufficiently attenuated to be irrelevant by the time that Sergeant Kaiser made his 7 requests in 30 seconds to search the vehicle.
When you use the word attenuated, you have to, I think, trace it to an ultimate illegality.
Yes, Your Honor.
And the ultimate illegality, as I understand with respect to the repeated questioning, I think, based on reading your brief, has to do with your unpreserved argument regarding coercion. Do I have that wrong?
The illegality present there was the fact that Sergeant Kaiser conducted a warrantless search after purportedly receiving consent from Mr. Kaiser to conduct such a search. The circumstances make clear that Mr. Coleman could not have given voluntary consent in those circumstances. And so conducting the search of the rental car without Mr. Coleman's voluntary consent made that action illegal.
But the consent allegedly only occurred, right, after your client had been identified as somebody who had committed AUO.
That's correct, Your Honor. The search,
So forgive me, thank you for your stopping at a dime perfectly. Doesn't it matter that nothing happened vis-a-vis the search of the vehicle until after your client was essentially arrested for AUO?
consent given after improper escalation is invalid, as this court held in Carr. Mr. Coleman did not give voluntary consent here because the 7 requests made in 30 seconds improperly escalated the stop. So even if this court is not willing to give merit to the fact that the stop was improperly escalated when Sergeant Kaiser asked about the contents of the vehicle, Mr. Coleman could not have given voluntary consent after the illegality of the 7 requests in 30 seconds related to requesting Mr. Coleman's consent to search.
Why don't you take us, I think, to your next issue has to do with the 440 motion?
That's correct, Your Honor. The 440 motion touches on multiple issues. The first of which is that Mr. Coleman's waiver of his right to a trial by jury was not voluntarily given.
Do you mind if I ask? I'm going to ask you a practicality. We do this from time to time, Mr. Cooper, but here your client received the minimum for CPW, correct?
That's correct, Your Honor.
And received a reduction of the felony narcotics charge, controlled substance charge, down to the misdemeanor for which he got a conditional discharge.
It was reduced to a misdemeanor. That's correct, Your Honor.
And so have you consulted with your client about what if he gets what he wants and he gets a hearing and the hearing results in a finding of ineffectiveness for any number of grounds, perhaps, and then he gets a new trial on the indictment? So he would be tried all over by presumably a jury on the indictment for the same charges for which he's probably served most of his sentence. And I know those are practicalities, it's for a future day, but if you've consulted with your client on that.
We have not yet spoken to Mr. Coleman about what would happen in the future proceedings. But
you're not there yet.
We're not there yet, Your Honor. But whatever answer he could give us would not change the fact that his waiver in these circumstances was not voluntarily given. Mr. Coleman waived his right to a trial by jury, believing that it was the only circumstance that would allow him to receive effective assistance of counsel. In so doing, he effectively traded one constitutional right for another. This court cannot allow such circumstances to stand. He believed that was the case because when he arrived for trial on the morning that trial was scheduled to begin, trial counsel was empty-handed and unprepared. He directly told Mr. Coleman that he was not ready to defend him at trial. He improperly pressured Mr. Coleman to take a plea deal in order to avoid having to represent Mr. Coleman at trial. And he repeatedly attempted to speak with the court to seek an adjournment because he was unprepared to represent Mr. Coleman on that day. Mr. Coleman wanted to pursue a defense at trial and repeatedly told trial counsel that he was unwilling to take the plea deal that the people had offered him. But his trial counsel wasn't ready to do so. And so Mr. Coleman effectively was forced to trade his right to a trial by jury to buy his trial counsel a single afternoon to prepare to give him a defense. That circumstance makes clear that Mr. Coleman's waiver of his right to a trial by jury was involuntary. Now, the court here did engage in a very brief colloquy related to Mr. Coleman's understanding of whether he understood what would be accomplished by waiving his right to a trial by jury. But none of the questions asked by the trial court touched in any way on questions of voluntariness or would have been able to uncover the circumstances that led to Mr. Coleman's jury trial waiver.
Now, counselors, I understand it, though. This is really a unified argument that you're making here, that the attorney from the beginning, this is your point, from the very beginning of the representation was ineffective. I mean, we're going back to the suppression argument. Justice Kern's questions, is this preserved or not preserved? As I understand from your brief, that's the heart of the argument as it relates to suppression, that there wasn't cross-examination vis-a-vis the body cam footage, that the officer really wasn't pressed as to his version of the events. And then that's carried all the way through. Your request here is to develop the facts, and as I understand it, that are actually outside of the record.
The facts related to suppression, Your Honor, are within the record because they are visible on the body-worn camera footage.
But your point is, I think your point, though, is that the attorney didn't talk to your client to say what actually happened during the arrest. Right?
That's part of it, Your Honor.
And if he didn't watch the video, he wouldn't know.
Correct, Your Honor.
So the idea that the officer wrongly escalated, the attorney wouldn't even make that argument if he hadn't talked to the client to know that or hadn't watched the video.
He would have been unprepared to, and he was unprepared to do so.
Right.
Yes, Your Honor, that's correct. Now, this court is able to and entitled to review the body worn camera footage, as Judge Curran stated that you all have, and the facts are clearly visible on the body worn camera footage. So it is possible for this court to reverse the lower court's motion, ruling denying Mr. Coleman's motion to suppress, grant suppression, and dismiss the indictment. And we would ask the court to do so. But you're correct, Your Honor, in that throughout the course of these proceedings, from the very beginning, when Mr. Coleman retained trial counsel failed to prepare, failed to review the law, failed to review the facts, and constituted ineffective assistance of counsel from the very beginning to the very end. These circumstances, I would hope, are fairly unique, but this court has repeatedly held that failure to prepare constitutes ineffective assistance. And because trial counsel provided ineffective assistance in these circumstances, Mr. Coleman's conviction should be vacated.
Mr. Cooper, I'm going to do something I rarely do, but I didn't see a note that I wrote to myself last evening about this case, and I'm going to take you back to the first issue.
Yes, Your
very
Honor.
briefly. Straining to hear on the BWC video, do you agree that the last exchange, the 7th or 8th, whatever, do you agree that your client said, yeah, you can do whatever you want to do?
Your Honor, honest answer to that question is I can't hear those words.
Fair enough.
But if you look at Mr. Coleman's prior responses to the questioning, when Sergeant Kaiser asks, be it his 3rd, 4th, or 5th request to search the rental car, Mr. Coleman essentially gives him a no. He tells him, I told you, it's all there is weed in the book bag. Speaking person to person, that is not consent. That is no. Earlier, Mr. Coleman does ask for clarification, which I understand in the circumstances might warrant a follow-up question. But when Mr. Coleman answers the question that way, I told you all it is weed in the book bag, that's a no, Your Honor. And Sergeant Kaiser should have taken that no for what it was.
I think we have your argument. All set, sir. Thank you.
Thank you very much, Your Honor.
Ms. McCarthy, good morning.
Good morning, Justice Curran, Marty McCarthy for the people. I guess I'll start with the suppression issue. The way I heard the words on the body cam or the way you heard them, but I don't think counsel's obfuscating the fact that he may not have heard them because they are not, I will admit they are not clear. It's difficult to hear those words. The general tenor of the conversation, no, is him not saying no, it's just weed, it's just weed.
But the general tenor of the conversation, he didn't say yes.
Until yes. I will
Just
give
do whatever you want to do.
I would take that as the officer or Sergeant Kaiser took that as a yes. I would submit that is a yes in this scenario.
And the other aspect of this is that that body cam footage really wasn't presented during the hearing, was it? I mean, the officer wasn't challenged with his version of events vis-a-vis the body cam footage, was it?
You're getting to the ineffective assistance of counsel.
Right. But just to be clear, I mean, that's part of the problem here, right? And what are the facts in terms of, I mean, the court's conclusions were drawn principally from the officer's testimony at the suppression.
Mhm.
And the argument is that a fair analysis of the facts would have required defense counsel to challenge the officer with that body cam footage, correct?
To shift gears to get to the ineffective assistance of counsel argument, I'm not going to stand up here and pretend that this was the gold standard of criminal defense. Unfortunately, it's not. You're not entitled to the perfect defense. You are entitled to an effective defense. In that scenario, defense counsel may not want to spend time on the body worn camera footage at the hearing because he may have concluded what I concluded is that in the end the words were go ahead and do what you want. So in that sense, maybe he didn't want to highlight it. Maybe he wanted to leave that ambiguous for the court to hear. That might be a reasonable strategy under the circumstances.
Ms. McCarthy, to take you back, Justice Duncan, you all set, I didn't mean to talk over.
Yeah, sure.
just take you back to the first point.
Yes.
Do you think it's correct that just in terms of the finding of consent, forget about consent being limited to the backpack or book bag or coercion argument that's in the brief, both of which I think you would say are unpreserved.
Yes.
But maybe we could reach those in the interest of justice.
Maybe you could.
But just in the terms of the court's finding of consent, in order to go the defendant's way on that issue alone, we would have to find that the court erred with respect to a finding of consent and have a reason for finding such error, such as the only one that comes to mind for me is that the credibility of the officer should not have been taken as accurate or proper. I mean, how else do we get at the consent issue from your perspective?
I don't know how you do it on a credibility basis, given the fact that you have his testimony and you have his body worn camera, and the two things don't conflict with each other, and there was no other evidence to indicate he was incredible on any particular topic. So to reach it on a credibility issue, given what's before the court, I don't think you can.
That's what I'm driving at. I'm not sure I have found a way, and I'm not sure we see one from the appellant's brief, as to just if we look at the concept of consent and the court's finding thereof, I'm not sure we can set that aside unless we go down the credibility path. And therefore, the only way to get to the defendant's arguments would be through the interest of justice on the scope issue and the coercion issue. You probably agree with that. But if you don't, let me.
Do I agree with that's how you would have to do
Yeah.
it? Yeah, I would have to agree with you there.
What's the counter argument, Ms. McCarthy?
With whether you could reach those issues or not, there is no counter argument to that fact. You're the appellate division under CPL Article 470 has interest of justice jurisdiction. So there is no counter to that. It's up to you whether to exercise that discretion or not to go down those, I don't want to call them rabbit holes, but you get what I'm saying. Those alternative arguments that were not preserved below. I can stand here and make an argument that this isn't a waiver appeal case. There's nothing like that to stop you from exercising the interest of justice should you choose to do so. So,
why don't you take us to the second issue in case you want to cover anything further?
I just wanted to I'll just mention the fact that you were correct when you pointed out this wasn't an escalation of a traffic stop. This was an arrest for an aggravated unlicensed operation in third degree, which is a misdemeanor. So at that point, it's lawfully in custody. The encounter escalated itself based on the criminality of the defendant. To the 440 issue, we argue in the brief that it's procedurally improper because it came before the entry of judgment. And CPL 44010 explicitly says that the motion has to come after judgment. Putting aside the procedural arguments, because I'm sure you don't want to hear those. You've read enough of them in my brief. When it comes to ineffective assistance to counsel, you do have to look at the argument in totality. Did he provide a reasonable defense throughout? If there was no defense if he did the best he could with suppression, he also did the best he could at trial in the sense of he cross-examined witnesses, he obtained an acquittal on the top count, which is the B felony. He was replaced between plea and sentencing, so there's nothing to discuss with him in terms of performance and sentencing. To the waiver of jury trial issue, that it's a weird issue because it's an issue that firmly presents on the record for appeal, but the appellant's argument is also stuff that happens off the record as well. But what's on the record belies what happens off the record. So when asked, when the court does the colloquy for the waiver of appeal, there's nothing in that colloquy that suggests that any of this happened in terms of defense counsel's statements to the defendant and as such.
What about defense counsel's arguments or contention that the 440 should have had a hearing? There should have been a hearing on some of the issues that was raised in the 440, and instead the court decided this, at court without any witnesses.
Which is weird because that argument's being made in the face of the procedural irregularity of the 440 in the first instance. That being said, if this court found that if the court found here, if it was going to excuse the procedural irregularity and the court finds that ultimately those raises issues of fact, then what the court would have to do, if it otherwise would affirm the appeal, would have to remit for a 440 hearing in that scenario.
We have an interesting twist here because the attorney is deceased,
And he's deceased.
right?
So-
So the only witness is the judge,
I'm sorry.
the judge.
He potentially would be one witness, yes. The prosecutor might be able to shed some light on what happened that day as well. But ultimately, it would be the defendant who would be the witness in that scenario.
That's the defendant's intention. He wasn't there for that conversation between defense counsel and the judge.
Oh, yeah. Oh, you mean the one in chambers? I'm sorry.
That's right.
Yes, and he was not. So the only two people, the only person that could testify to that would be the judge.
The judge would be a witness to that, which is a principal point of contention here the defendant has raised, that the reason for the request to go to the bench trial was due to lack of preparation. There wasn't the defendant's position, there was no strategic reason for that. It was just, that was the attorney's escape hatch because he was so unprepared, couldn't go to trial.
And if the court were to grant a hearing, as we find out whether that's true or not.
Right.
But, you do see occasions where a defense attorney would counsel a defendant to take a bench trial or a jury trial because maybe they're looking for what exactly happened here, which was a minimum sentence.
But coupled with the defendant's other contentions that my attorney wouldn't meet with me, wouldn't return the phone calls. We met sometime at bars, I guess, was in the pre-sentencing report. And in addition to all the other witnesses saying that the attorney was either intoxicated or under the influence of alcohol throughout the whole proceeding, that might require a hearing.
It might.
And to follow up on Justice Del Conte's, not challenging the validity of the stop, not challenging the testimony of the officer. This all feels into the ineffective assistance of counsel, wouldn't it?
Well, I mean, he did challenge the validity of the stop, but he did not actively engage in cross-examination of the officer. So I will agree with you, at least in part, that he didn't do that. And the court can certainly look at that in determining whether he received effective assistance or not, if the court's going to reach that issue based on the procedural and propriety of the 440.
I think we're all set.
Thank you.
Number 780 is submitted. Number 781 is submitted, as is number 782 and 783. That'll take us to number 784. People v. Demetrius Williams. We're all set, Counselor. Good morning.
Your Honor, good morning. May it please the court, Leah Farwell for Appellant Demetrius Williams. In the spirit of keeping things to our salient points, I will be focusing on point 1 of the appellant's main brief, which is consecutive sentencing. Your Honors, at its core, this case presents a very simple issue.
This is, I'm going to go right at it. So,
Your Honor.
this is the issue where you're contending that the sentences had to be concurrent, correct?
Yes, Your Honor.
And the
Pursuant.
rationale for that is that there's no evidence separately of possession other than when the weapon was used.
Yes, Your Honor. And more specifically, where a single act constitutes one of the offenses and a material element of the other. And it is Mr. Williams' argument that the two charges, which, just to remind the court, were assault first and criminal possession of a weapon second, they share an actus reus. So here, the people allege in the indictment that Mr. Williams possessed a loaded firearm and caused serious physical injury to the victim. The crimes involved, as I said, the same actus reus, and the possession charge constituted a material element of the assault. And once we get there, it is the people's burden to establish separate acts, and they failed to do so both at trial and at sentencing. And here I would just like to point to Hamilton, People v. Hamilton, which is a Court of Appeals case from 2005, where it is I believe the same charges, where the court found that in order for there to be proper consecutive sentencing, it would have been necessary for the people to establish that the defendant possessed the weapon with a purpose unrelated to his intent to shoot the victims. And here, the people did not establish that. It was always their burden, and they did not establish that there was that Mr. Williams possessed a firearm with any intent other than the assault charge.
Counsel, just I spent as much time as I could afford on looking at that issue. And then I came across a case, I'm not sure anybody cited, but it's relatively recent for the Court of Appeals, People versus Malloy. And then I think there's People versus Brown after that. I agree with you with the cases that you cited in your brief that predate that, and I'm not sure there's a change in law. But the Court of Appeals there says, so long as a defendant knowingly, unlawfully possesses a loaded firearm before forming the intent to cause a crime with that weapon, the possessory crime has already been completed. So we have to find out, is there a moment, so to speak, in time when the evidence would show, or at least infer, that your client possessed a weapon before he used it with respect to the assault. And given I've watched that video, especially the critical points. I see in the video, in case I'm wrong, and you want to give me a different version, I'm floating this for you. But in the video, I see your client, who's identified by Mr. Lee, and I think by Ms. Morrison, but I forget, but definitely by Lee, essentially shove his girlfriend, whatever, Tashika, I think it is?
Yes, Your Honor. His wife, yes.
Shove her. But then he doesn't go anywhere else except for a moment outside the screen, sort of above it. But the whole time he's there. So isn't there a reasonable inference that during that whole time, he must have already had that weapon during that whole time before he shot the victim?
Yes.
So that's what I'm struggling with. That seems to me that there is an inference to be gained there that for at least a moment before the shooting, that he possessed it. So I'm not so sure I can agree with your argument if that's a proper construction of the facts. Go right ahead.
Your Honor, I think that People v. Wright, which again is Court of Appeals from 2012, tells us to consider the point at which the relevant intent changes. And you point to exactly the moment that I think is relevant there. The facts are uncomfortable. He shoves his wife. If he intended to use that weapon, he never drew that weapon against his wife. He drew it against the men that he had an issue with at the party. And I think at that point, that is where we need to look to intent. And this court in People v. Plume in 2016 and People v. Torres has upheld the Hamilton framework, where possession is second and attempted assault in Torres and I believe assault in Plume, because the weapon possession charge was completed.
So counsel, you don't disagree though that the defendant formulated the intent to use the gun after, at least moments after he assaulted his wife?
Your Honor, I think that he left the party to retrieve his gun after he saw his wife flirting with men at the party. And at that point, I think that intent was formed. I don't think that his intent all of a sudden crystallized at the point when he shoved his wife. It may have narrowed, but I think that always that was the intent. And I would just like to close here by really driving the point home that Mr. Williams is serving an illegal sentence. This is not a term of months or of a year. This is 15 years. This is 40 years versus 25 years. And I just want to follow up on Justice Presiding's question. And from the Brown court, it says the crime of possession is already completed from possessing the instrument and having it on him prior to the other crime. So it could be two separate instances. The possession is already completed because of the fact he had the instrument on him before the alleged assault happened. Your Honor, I think that goes to the actus reus element of this, of looking at these charges, and when one charge is a material element of the other, and it was one continuing act. Does that answer your question, Your Honor? I know that's your argument, that is one continuing act, but there's case law, and I think that's what the Justice Presiding was saying, that there's the Brown court said that act or that crime is completed with the possession.
But your argument is that it's one continuous act.
Yes, Your Honor, and I would just ask this court to continue with the precedent set by Torres and Plume, and more recently in Hillard Smith, which People v. Hillard Smith, which I did not cite in my main brief because it was different charges. But Your Honor, Bannister and Justice Curran were on that panel as well, and I think it sets a precedent here. So if there are no further questions, I will lie my papers. Thank you very much.
Thank you, counsel.
May it please the court, Jerry Marti for the people. As has been discussed, intent was formulated after the defendant had already possessed the gun. The intent was really formed when the victim had choice words with the defendant. It was at that point that he pulled out the gun and shot him 4 times. I would just point just quickly to page 6 of the last sentence of the respondent's brief. It indicates that they agree with the people's position because they say that the defendant didn't inform an intent to use it against his wife since it was not used until one of the men presented stepped in to defend Tiashika, that is the defendant's wife, and that is the moment when the victim stepped in. Lastly, as to the harshness and severity point, this case checks off all of the Farrar factors: societal protection, deterrence, and rehabilitation. This was an execution-style shooting that left the victim quadriplegic, and this sentence is just and fair under the circumstances. I'll rest on my papers, and unless there's any other questions.
We're all set. Thank you.
Thank you.
Next case for argument is number 785, People versus Dent.
Good morning,
Go
May
ahead.
it
Go
please
ahead.
the court. James Eckert for Ronald Dent. We submit that the trial court committed reversible error and refused to charge justification in this case. It was preserved by extensive argument by defense counsel and by a written motion when the case adjourned overnight. Mr. Dent, 5'7", faced 6'3" Mr. Henry, who engaged in an extended tirade after being rebuffed by the mother of Mr. Dent's children, and during the course of this extended confrontation was often accompanied by 2 other people. The people argue that there's no testimony that Mr. Dent used force in an effort to defend himself or others, but that can be inferred as the people infer all of his intent. And the need to protect Mr. Moore and the mother of his children is clear. Mr. Dent did not respond with any kind of force inside the bar when he was bumped. He did not respond with any kind of force when Mr. Henry continued his tirade outside of the bar. It's only when Mr. Henry came down the handicapped ramp in the direction of both Mr. Dent and the mother of his children that he moved toward Mr. Henry, and that's when the fight began.
Well, even if that's the case, and that there was some approach by the victim to the defendant here, that I believe the people's position here is that the defendant brought a knife, and there's no evidence in the record that the victim had a weapon of any kind.
Mr. Dent has a cut on his hand, and there was broken glass at the scene. There's no direct testimony, and Mr. Henry denied the possession of a weapon and so on, but Mr. Dent faced deadly physical force in the form of someone who is substantially larger than him and accompanied by 2 other people, and who additionally was given his irrational response to being rebuffed, presented a serious danger to both himself and Ms. Moore. And it's correct that the conviction involved the use of a knife, but I don't think the absence, first of all, viewing the evidence in the light most favorable to the defendant, there's reason to believe that Mr. Dent was caught by something. And
during the knife fight, and we watched the video, the video here where the defendant is, leaves the bar, races to the white Charger, and then runs back towards the back parking lot and immediately starts swinging and striking at the victim. And it's your position somewhere in there. There's a bottle that the victim picks up, or he has a knife of some kind. And even though that's
I mean, that's not the only basis for saying that there's a justification charge warranted here. It's the size of the other person and the fact that he's accompanied by two other people. Mr. Henry's testimony is the most serious injury occurred immediately, but there's no blood there. This is an extended tirade, and you can see from the video that there's a point at which Mr. Henry is following Mr. Dent, as a point in which Mr. Dent is on the ground surrounded by three people. And it's Mr. Dent was also responding to Mr. Henry, who took off his jacket and arranged his pants in anticipation of the fight. So, I mean, looking at someone, Mr. Dent is maybe an inch taller than me, and Mr. Henry is 6'3", and with two other people, I mean, there's serious danger there, both to Mr. Dent and to Ms. Moore. And I think effectively the court, I think the court determined because Mr. Dent went to the car that he was therefore free and clear. That he could have just left at that point. I think the court point at one point says that's dispositive, but Mr. Dent is not the driver. Even when Ms. Moore is in the car, Mr. Dent's trying to get to it. Mr. Henry is cutting him off. He denies doing that on purpose, but the effect is that he's cutting him off. He's following him along. So I think the jury, under the circumstances, would have been entitled, viewing the evidence in the light most favorable to the defendant, would have been entitled to conclude that Mr. Dent believed that he was in danger, that Ms. Moore was in danger, and deadly physical force was warranted under those circumstances. And I think Mr. Dent effectively has not had a jury trial, because the only issue would have been the attempted murder, which was never a strong case, and that everything else was effectively a bench trial. Point two, outside the presence of Mr. Dent and his attorney, the court committed a reversible error in telling an important prosecution witness that she was lying when she said she didn't recall the events, and to stop lying. Now, the defense doesn't have an inherent right to be present in a material witness proceeding. I don't submit that that was, but as this court ruled in People v. Phillips, that if the material witness proceeding veers off into something else at which the defendant does have the right to be present, it's reversible error to do that. The court effectively tells an important prosecution witness to change her story, that that she was lying when she said she didn't recall the events, and to stop lying. And that effectively denied Mr. Dent the right to cross-examine her about her having apparently lied to the judge in this case, cross-examine her about the judge having instructed her to stop lying, and additionally that she was held in jail over the weekend, to emphasize the need to stop lying, which I submit means change her testimony. And that none of these things were revealed to the defense or his attorney until I saw it in the transcript. So I think those are all important things that the violation effectively amounted to a violation of the right to counsel, a violation of the right to be present in a material stage, and a right to cross-examine an important witness. She was the only witness who said that he told, Mr. Dent told her on the way away from the proceeding, there aren't any fair fights, implying that he had a weapon and Mr. Henry did not. Thank you.
Thank you.
May it please the court, Bridget Field on behalf of the people. I'm going to start off with point two first. I believe that the material witness hearing was appropriate in this case. The judge did not tell Ms. Peterkin how to testify. And in fact, she came into the material witness hearing and said, "Why am I here?" Something to the effect of, "Why am I here? I don't really remember anything, or I don't know anything." In fact, she testified 28 times. She answered, "I don't recall." So there's absolutely no indication on this record that anything that the judge said changed her testimony, that she was lying. Again, she testified 28 times, "I don't recall," in response to questions from the people, as a matter of fact. So there wasn't any, she didn't offer any testimony at the material witness hearing. There's just no basis in this record to indicate that she changed her testimony in any manner based on the judge saying, under the circumstances, I don't believe that you don't recall anything. And the defense counsel was certainly aware at the time that Ms. Peterkin testified that she was there pursuant to a material witness order. She would have been there she was held in custody. And there's comments on the record that would have indicated that defense counsel was aware that she was in custody prior to the time of cross-examination. And typically, if you're in custody, there is a court deputy with the individual who's testifying. So defense counsel certainly would have been aware that this was not a witness that was that wanted to be there. And in fact, Ms. Peterkin testified to that she didn't want to be there. She didn't want to be involved. So I don't think there were any problems requiring a reversal in this case with regard to the material witness hearing. And with regard to the justification defense, I think that the court was appropriately denied the justification defense. The defendant did have a cut to his hand. It was to his dominant hand, and this was a stabbing. There were the victim had received 9 stab wounds in this case. Well, there's no testimony how he got that cut. It could have been during the fight.
Was there any evidence that the other folks involved in this fight were the aggressors?
That anybody else in all the people in the area? No. Not that I recall. There was no, and even there's mention of the 2 men that were with the victim. There's absolutely no testimony that they were aggressive in any manner or that they had done anything to create any type of fear in the defendant.
Separate ways at one point.
Yes. And the video is in evidence. I'm sure that the court has looked at the video. I apologize. I did not review the video last night, but the video clearly depicts, well, it's a little blurry, but you can see, how the people travel, because this did start, there was apparently a verbal altercation inside the bar. The parties were separated. They left separately. The victim admitted that he was mouthy, he was saying inappropriate things, but saying inappropriate things is not the same as being aggressive with deadly force.
I see, my view of the video, I see the defendant identified by the witnesses running over, I guess it was to the charger, but then running up either to the back or side of the victim, and you can see this.
I agree, Ritter. No, I agree. And there's also mention, or defense counsel has mentioned this bottle. There's absolutely no testimony or no evidence to link that bottle to this case. There's no DNA evidence, there's no fingerprint evidence, and there's no witness testified that anybody was seen holding that bottle, using that bottle. So to use the fact that there's a broken bottle in a parking lot outside of a bar, doesn't justify a defensive justification in this case. I would rest on my brief unless the court has any further questions.
We're all set. Thank you.
Thank you.
786 submitted. 787 submitted. Brings us to number 788 and the matter of Fortney and Rivers. I think everybody's by video. Mr. Earhart, I see that you're on mute, but I want to make sure you can hear us. Can you hear us, sir?
I can hear you, Your Honor. Yes, thank you.
Excellent. To my knowledge here, we're still waiting for more, Ms. DeGiorgio to join us.
Okay.
Your Honor, she has submitted.
She has submitted. Okay, I didn't see it on my list. Thank you. Mr. Earhart, so your opposition has submitted in this case. Do you wish to be heard with respect to any issues?
I do, Judge, if it pleases the court. Very well settled in the law that unless there is a lack of a sound and substantial basis in the record, the trial court is afforded great deference in their determination. The most important aspect of this case is the 542 pages of text messages which were submitted. There was testimony that the only means of communication between the parties was via text message. So a very long review of the messages is the most definitive proof of, and it eliminates the he said, she said of this. If I had restated every instance of the appellant's threats, vile comments, threats to call CPS, threats of legal action, I would have far exceeded the word limitation allowed in my brief exponentially. The court had a sound and substantial basis in the record to make the determinations that they did, and their ruling should be upheld. The other thing I would note for the court, since these briefs were filed, there has been a subsequent action involving these parties, as well as a new third party, being the paternal grandmother of my client. Ms. Fortney participated in that case. There was the start of a trial, which ultimately ended with a consent order giving custody to a new third party that would have had to have established extraordinary circumstances in that case. Ms. Fortney derived a benefit from that case as well, in that she has now obtained joint legal custody with the other parties to that action. So in my opinion, this case is now moot, given the subsequent action.
We need to see that paperwork, and I think there was some obligation on behalf of counsel here. I'm not saying you, sir, but to let the court know that in light of a pending appeal, that there were not only subsequent proceedings, but that they resulted in, I mean, I don't mean to complain about doing my job, okay? But the amount of time that I spent, on this case, reading those text messages and being prepared to be here today would have been put to other use had we known that. And please take that into your thoughts, next case like this, where we shouldn't have even spent the time talking to you.
I understand, and I apologize. I did not receive a copy of that order until maybe 2 weeks ago.
Okay, and 2 weeks ago would have been a wonderful time for us to have known that as well, okay?
I apologize.
Okay, and I hate to shoot it just at you, the criticism, but please, pass it along to your counsel on this case as well.
And Mr. Earhart, while we have you on that issue, if there are extra documents, things like that to be submitted to show that this appeal has been mooted out, it would be great if there was a joint submission, if that could be worked out, so there's not a back and forth. But I'll leave that to the lawyers, and that would be appreciated if you could do it. But other than that, is there anything else you want to be heard on, sir?
There's not. Thank you.
Thank you very much. 789 is submitted. 790 was settled. That brings us to 791, Robert Madison et al. Versus the State of New York. And Pajak, good morning, sir. I think we're waiting for Mr. Hitchens to be by video. Just give us a second.
No problem, Your Honor.
There is Mr. Hitchens. Good morning, sir. Can you hear us okay?
Good morning, Your Honor. Can you hear me?
We can hear you. So we're going to let Mr. Pajak have the podium get started. Just so the lawyers know, we're going to do 791 now, and then just as the calendar reflects, we'll do 796 later. It just seems to me that we have two calendar numbers, two docket numbers, And that way the people in between don't have to be waiting either, and we can cover this at the end. Mr. Pajak, we're ready for your argument on 791.
Great. Thank you, Your Honor. May it please the court, Greg Pajak from Salino Law for the Madisons. The issue, of course, is the abuse of discretion standard here, dealing with the application for a late claim. The problem here is that the Court of Claims, in implementing and looking at the 6 factors under Court of Claims Act 10-6, engaged in a very rigid, hyper-technical analysis as opposed to what it was supposed to do, which is a more liberal analysis of the facts to see if it's appropriate under the law, whether or not a late claim can be filed. I will admit, of course, that the Court of Claims did get some things right, gave 3 out of the 6 to the claimants on the issue of notice, investigation, and prejudice. And I would submit that those are probably combined the most important, because isn't the main issue in dealing with an application for a late claim, is the defendant going to suffer prejudice? Can they still defend themselves on the claim? And here, the Court of Claims said, yes, they can. The state is not prejudiced. They're going to be just fine. That also dovetails into the reasonable excuse issue. And while that certainly isn't a standalone prong of the analysis, I do think that the fact that there is no prejudice and only a 2-day delay further weighs on the excusable delay aspect, because what's the harm here? There is no harm. So I really want to focus now on what I view as a hyper-focused analysis that the Court of Claims did on the merit of the case and the claim. And instead of simply looking at whether or not there appears to be merit, it looked to me like the court determined whether or not there was merit. In other words, was this a claim which effectively would survive summary judgment? I've seen a less strict analysis in a summary judgment situation as opposed to what we have here, which is there anything cognizable here to show that there is merit to the claim? And the fact
means, just to follow along on your analogy to summary judgment, you're saying that you would have granted plaintiff summary judgment on these papers?
Granted the claimant's summary judgment?
That's why I understand your argument.
In their favor. Sure. Not really, Your Honor. But I do think
I would get a laugh, Mr. Pajak. That's what I was going for.
you got a smile, at least a snicker or a guffaw. I'm not sure which.
That's all I need for the day.
But you got something from me. But the reality is, though, that with the evidence that was on the first motion just for the late claim, there was evidence of merit, and notably whether or not the state did in fact own or control the cave area where this tragic situation, this accident occurred. There were the news articles. There's discussions from the Lockport mayor, State Senator Ort, talking about in the past relative to a 2015, another incident, whether or not the irregular inspections that the state subsequently did after that 2015 accident were sufficient. Well, if the state was performing inspections after 2015, it just begs the question of what they did relative to this incident in 2023. Certainly that is enough to show that there was some issue dealing with the issue of ownership and or control, which would impose potentially liability on the state. The other problem is,
Mr. Pajak, don't lose your train of thought, but this is really what I'm struggling with. And then also, I know I tried to have a lighter moment there, but this is a serious matter for your clients, and I don't want to take it lightly. But so if we were to write it up your way, so to speak, on this appeal, we would have to reverse. And in order to reverse, we'd have to find error by the Court of Claims. And the error would seem to have to be rooted primarily in the court's merit findings, which some cases say is the most important finding, because why go forward with the meritless claim? And I see they're having difficulty writing a memorandum in your favor, because is it the merit on ownership or possession? I didn't see much, if anything at all, on that issue in the motion papers. Is it a duty to do inspections? That is there some statute that requires it? Because you're not there, you're shifting from, and I'm laying it all out so that you can address it, okay? Owner and possession, that's one level. Duty to do inspection, that's got to be some sort of state obligation to fulfill a statute. There's certainly no contract. That is, there's no obligation. There's no Espinal issue. So trying to get to the merits of where there is a duty that was allegedly breached. So how do we write this up if we were to go this way? your way to say that here's the theory of the duty. And I'm just seeing, very honestly, quicksand and a slippery slope, but those are my concerns. Go ahead.
No, and I understand the slippery slope concerns because, of course, you want to, of course, I'll throw out Paul's graph because it's always fun to quote poor Mrs. Paul's graph at some point.
And it's clear abuse of discretion is our standard, as you know. Go right ahead.
It is a clear abuse of discretion, but here again, I think the errors were both legal and factual, which cobbled together with what is supposed to be the liberal standard and the application of 10-6 shows that this was an abuse of discretion. Because, and again, you have to look at the context of when this application is made. It's made at the very beginning of the case. There is zero discovery. And for any claimant to be able to conclusively establish the merits beyond a doubt or beyond all reason or beyond all question at the very infancy of a claim is almost impossible.
You only really need to establish that there could be merit.
There could be, correct, could be. And that's a lower standard than, again,
Far lower.
far lower. And we said there could be a claim here based on, to your honor's point, on the ownership issue. There's a conversation again from the mayor and the state senator. Now that
But
they also
get to that on this record.
just from the news articles.
News article. I
Yes.
misspoke. Okay, I'm wrong.
We're not at the other with the affidavit yet, correct. But just with the news articles, I think the standard is quite lowered to Justice Bannister's point, and there's enough with the news articles alone. They also touch on the inspection issue. And whether or not there's a state statute which mandates the inspections, there's clearly some evidence in the record, and I think some evidence, if you're looking for the standard here, Your Honor, I think it should be, is there some evidence to show that there is a potential meritorious claim? Not that claimants are going to win. There can only be, at the infancy of any case, some evidence, and there is some here.
Now, there were other claims that were filed. For
Correct.
this very same accident by other claimants, correct?
That's correct.
And they're viable claims going forward.
That is correct.
Okay.
In Supreme Court and Court of Claims.
Right, but those people didn't have to make the showing that your people had to make in order to file a late notice of claim, albeit very slightly late.
Correct. They did not. The standard here was so high that it really was an impossible standard for any claimant to meet. And that's how it reaches the abuse of discretion standard, which I acknowledge is a tough standard normally to reach. But here it has been met because of the lower standard, the overall context of the case. And there was certainly sufficient evidence here to allow the claim to proceed. Now, whether that claim wins the day, we shall see. Do they get out on summary judgment once there's all discovery? Perhaps, but just allowing the case to proceed when there is no prejudice, no harm, opportunity to investigate, a couple of day delay.
But back to my question about the duty. You went off on the newspaper articles to suggest that. I don't see where those newspaper articles address the ownership. In fact, as I understand it, they quote the owners.
They do.
And the owners are not the state of New York, and they identify those owners. And so if you go to the articles, you don't have an argument at all that's meritorious on ownership or possession. So that's why I'm thinking, if you got to give us something, that we can't just kind of sweep it under the rug here, because we have so many of these cases, Mr. Pajak, where if this had been a grant, this might be we'd be facing the same standard. So I really need you to help me out. If you want us to want me to go your way, to find a way to say, where is the merit here vis-a-vis the duty?
Well, the duty, I think you can also assume a duty, because based on the news articles dealing with not ownership, but more focusing on the inspection issue, if the state in the past had assumed the duty to inspect after the 2015 incident, someone who assumes the duty therefore must carry that duty out appropriately and faithfully.
And where is the evidence that the state, by your words, assumed a duty?
Because
typically the state doesn't assume a duty, they do it pursuant to a state statute or regulation. I don't see that identified here. So where is I think you're arguing, see, that's assuming a duty. Where does that come from?
it comes from the state senator in the news article where it said that there were irregular inspections in the past, which he was not happy with. And you don't perform the state of New York. Certainly, the state of New York is not magnanimous. They're not just going to sit there and routinely inspect where they don't own something. So I would suggest that it certainly is implied in the irregular inspections and the evidence of the irregular inspections that the state had some kind of ownership or control interest over the cave system. That's why they did those arguably irregular and unsatisfactory inspections in the past, which gives rise to the duty on the part of the state going forward after the 2015 accident to do those inspections and do them properly. And the claim here is that they did not. So I think that gives you enough backing at this early stage.
The one view of this, that the court made a determination there was no duty, and that may not have been appropriate at this juncture in litigation, 2 days after the notice of the claim should have been filed.
I would agree with that, Your Honor. This was so earlier.
There's a lot of potentially unknown facts here at this stage.
Correct. And I think the bar that was set by the Court of Claims here was so high in its analysis that most claims seeking a late application like this would be denied. And that was not the intent of the liberalization of the Court of Claims Act. And unless there's any other questions, I will rely on my brief and see you again very shortly.
Very much.
Thank you.
You could stay up here if you'd like, but it's up to you.
I forgot he's on camera.
And if you prefer to sit, Mr. Pajak, you can do that too. Mr. Hitches, sir, you're all set.
No.
That's great, Your Honor. Thank you. The standard has gotten a lot of discussion in my adversary's argument, but I think one thing that we can agree on with respect to the standard is that it's not appropriate to allow a late claim to go forward that's just going to be doomed to dismissal. The state doesn't see it as the Court of Claims applying any kind of heightened standard, let alone an impossible one. It sounds like this court is aware of the other pending appeals arising from the same incident. Those were all dismissed on motion to dismiss grounds for the same reason. And frankly, this proposed claim, had it been timely, would have been dismissed on the exact same grounds. I feel compelled to clarify that there is no evidence refuting ownership. In fact, the Court of Claims, I believe it's page 8 of the record, goes through what we had submitted to establish that we didn't own the Lockport Cave or the boat within, and then says claimants have submitted no evidence to oppose this. And then claimants get a chance to appeal. They don't say in their appeal, wait a second, that's wrong. They contest the entire appeal on the alternative theory of negligence, which is a negligent failure to inspect, and they claim that they established a special duty. So when claimants are standing for the first time up here, articulating an ownership theory and saying that they've proven that, that's the first time that the state is hearing this, frankly. We understand that there's the motion to renew, but we're going to get to that. Now, I would also, even if this court were to find it appropriate to consider that argument at this late juncture, claimant's basis for saying ownership has to do with inspection. And claimant says the state wouldn't inspect something unless it owns it. And that's just transparently not true. The state has inspection functions constantly when it comes to things that it doesn't own. In fact, one of the cases on which we primarily rely is the Court of Appeals decision in Metz. We understand that arises under the navigation law, but that involved an inspection of a boat that the state did not own. Somebody else owned that boat, but the state was inspecting it for purposes of making sure that it was safe for public use. That is a governmental function. And when you have a governmental function, you have to establish a special duty. There are 3 recognized ways to establish a special duty. None of them applies here, and that doesn't matter what the standard is. If you look at the face of the pleadings, there's no basis to say there's a special duty. It has been argued that perhaps there is a special duty that arises under Article 27 of the labor law. And to that effect, there was some dispute below whether or not this boat would constitute an amusement device under the labor law. The state has consistently maintained that it doesn't. Claimants maintain that it does. Frankly, that's not something that this court needs to get itself into right now. Assume that it is an amusement device. There's still 2 problems. First, the obligation to inspect an amusement device arises only if there's been an application for a permit for that amusement device. We don't have that here. And second, going directly to this question of special duty, if the state had failed to inspect something that it needed to inspect, under these circumstances, that doesn't create a special duty. We know that because this statute mentions numerous consequences that would be incurred by owners. Entities like Hydraulic Race Company, which is acknowledged as the owner and operator of the boat, if they don't apply, if they are operating an uninspected boat that's supposed to be inspected, then the state can take enforcement action. The district attorney, in some circumstances, can prosecute. And we know that the legislature intended this statute to facilitate recovery. That is Labor Law 870-A. They wanted to facilitate recovery as to owners. Juxtapose that against a total silence about what would happen if the state shirks its responsibility to enforce the law. And the Court of Appeals has recognized on numerous occasions that the failure of the government to do its job, here the failure to enforce the law, is not a basis for liability.
Mr. Hitchens, real quick, and don't lose your train of thought, but something you said a minute or so ago, I want to make sure I get it right.
Sure.
The argument that Mr. Pajak has advanced here today about about these regular inspections, was that anywhere in the motion papers for the notice of claim? Is your argument that they never even raised that when they moved for permission?
No. So if I can clarify, they certainly raised this prospect that there had been inspections in the past, or at least that there's a question whether there had been inspections. But that went to whether the state had the power to inspect this boat under any kind of statute. It was never portrayed as a function of ownership, such that this would be a proprietary function.
Got it. Thank you.
Yes. So,
can I ask a question too? Can I just ask you one question?
Of course.
Did the Department of Labor conduct an analysis before the incident and determine that they didn't have jurisdiction?
That is something that the record is not clear on. So if the record had shown that the Department of Labor had conducted an analysis prior to the accident, that could pave the way for discretionary function immunity. That said, there's no need to send this back for further development because you would need a special duty regardless. So if there's a special duty, we would have an affirmative defense of discretionary function immunity if in fact this was a discretionary function. But we don't get that far because the labor law doesn't create a special duty. Now, claimants have alternatively posited that they could establish a special duty through the other two theories, voluntary assumption or positive control of a dangerous condition. They misunderstand the core feature of both of those theories, which is that there has to be some kind of direct interaction between claimants themselves and an agent of the state. The whole purpose of a special duty is that it goes as to the claimants. It goes beyond a duty to the public at large. That's a language that always gets used. And claimants' theory for voluntary assumption or control of a dangerous condition is that possibly in 2015, 8 years before the accident, someone from the state might have come out and inspected the boat. That is a textbook example of a function being performed on behalf of the public at large. There's no indication that anybody from the state was thinking about claimants. And on the date of the accident, there's no indication, A, that anybody from the state was around, B, that the claimants had any idea that this boat needed to be inspected by the state, which again, we dispute, or C, any kind of assertion that had they known that this boat wasn't inspected by anybody, they wouldn't have gotten on it. So those two theories swiftly fall by the wayside in the absence of those allegations. We're talking about an abuse of discretion standard for the appearance of merit that is measured against the claim that claimants proposed before the court. It's not measured against a claim that the court thinks claimants could potentially submit at a later date if they had a chance to reflect. And when you look at these allegations, which the Court of Claims remarks are actually quite conclusory, all the claimants really allege is that the state had a duty to inspect and it breached that duty. Now, they don't have to say the state had a special duty. There's no magic words. But special duty is a legal concept. What you have to do as a claimant is plead a set of facts that if taken as true, could support the existence of a special duty under any of the three recognized theories. They have not done so.
Mr. Hitchens, I think we have the special duty argument, sir. Anything further on your part?
So there are two additional grounds that the court went on. We invite the court readily to opine on the merits because it's going to provide guidance to the parties in the other pending appeals. But as to those two other grounds, I just want to comment for a moment about the availability of other remedies. The record reflects that claimants have in fact sued Hydraulic Race Company. We have no opinion on what's going to happen in that suit, whether that suit has any merit. We're not going to participate in it, but Hydraulic Race is the proper defendant to be sued, and that gives them an alternative remedy. Not only does it give them an alternative remedy, but that is the appropriate remedy.
Okay. Mr. Hitchens, thank you very much. And counselors, just we'll be back to you on the other one in just a couple of minutes.
Great. Thank you.
Thank you. Now, I've got to admit a mistake here, and with an apology, I skipped over the, go ahead, Mr. Pajak, you're all set. But in 787, let me call that up here. I failed to call that before. I think we may have somebody by video too as well, if my sheet is correct here, or I'm reading it right.
I'm not going to say you made the mistake, Judge, but
No,
I didn't hear it.
You don't need to. And the funny thing is, I even put a big green sheet up here that says respondents submitted, not everybody submitted. So
Oh, there's the AFC.
I
Okay.
also have no excuse for my mistake, but I do sincerely apologize to you and counsel for the extra time and the concern that must have caused you. But we're ready for your argument, sir. Thank you.
I had to apologize to my wife for the extra anxiety. She's sitting in the back. I'm John Rowley. I'm an attorney from Ithaca. Nice to be here. It's my first time. I want to set my 10 minutes. I'm sure you'll tell me, but I need to tell me too. I'm here on behalf of Gary Buehler-Newmar in a permanent neglect case. I think this is an interesting case for the court because it does start with a family that's very stressed. You see on the problems faced by the family, there's all sorts of mental health problems, all sorts of terrible history. My client had a terrible history. So when they lose their 5-month-old, when their 5-month-old is removed for them because they're not able to feed him properly, DSS has got to put a plan together. I won't argue with it. It's a generic plan, but it's the plan, right? It's go to mental health, go to parenting, go to visits, and keep a clean house. The problem here is that this is a formula and not a plan, because a plan involves getting information, evaluating it, making changes. And as we know, the court every 6 months is reviewing it. We've got permanency hearings, we're looking at it, but look what happens here. They go to mental health, they get psychological evaluations. Those never come to DSS. No one ever reads it. No one ever knows what the diagnosis is. No one ever knows whether or not this gentleman is supposed to be taking medication. So when he's coming to visits and he's exploding because he thinks his child was sexually abused, and of course he was raped as a 4- and 5-year-old when he was in foster care, they don't say, hey, you know what? Let's get together. Let's have a family team meeting. Let's get the counselor. Let's get the evaluation. Are you taking your medication? What do you do? How do we deal with the triggers? How do we deal with what's happening to you? Never happens. We just keep rolling on. Look at the situation with the parenting. He goes to parenting faithfully, doesn't learn anything. Well, he's a limited guy. Did you look at his education history? Did you look at his IEP? Finally, towards the end, the parenting educator says, you know what? I realize this guy isn't understanding what I'm saying. So I tried a new strategy. So I tried a different approach with him, something more concrete. So you know what? It worked. But by then it was too late. We were at the end of the line. The worst, though, the most egregious, as far as I'm concerned, is the housing. You go to their house, you got holes in the house, I mean, they have animals, you've got no heat at times, no water at times. It's a disaster. And they keep coming in every month. They say, it's a disaster, you got to change this. It's a disaster, you got to change this. There's never a discussion about Section 8. Where is the support from DSS? DSS has all the cards here. They control everything. Instead, what you get is the parent aide saying, 2 years on, she says, I keep telling mom to get public assistance, but she can't do it. Well, what you do to be an effective plan, and this is the threshold issue, right? The diligent effort is you take mom, you say, Mom, we're going to go over to public assistance and we're going to find out why for 2 years you've been unable to get the money. And they go over and say, oh, you know what? You never filled this out. You get it done. I mean, that's just the basics. This case is about what is the minimum for diligent efforts for a family that's a long shot to make it. I'm not, and the law guardian's gonna go up here, well, he's gonna be right there. Sorry, I expected you to be here, Mr. Burkhardt. He's gonna say, look, this child needs to move on. We need permanency for this child. Maybe so. Maybe that's what would have happened anyhow. But the government had the responsibility to put together a plan, to make changes, to reassess it, to get together, get everybody in the same room and say, hey, why are they still living in the same house? Why don't they have heat? Why don't they have water? What is going on here?
Okay.
Counsel, you represent the father, right?
Yes,
Okay, what happened with the mother?
she surrendered.
Okay, that's what I
Yeah.
did see. Well, you mentioned her.
I know I did mention her. It was probably a little bit off.
And there wasn't a lot in there about.
No, she surrendered early on. I just put a footnote in. Yeah.
What was the basis of her surrender? What were they saying she did?
Oh, no, the petition against her was the same. She just didn't contest the case
Did she continue to live in the house with the father and?
for a while.
Okay,
And then that turned over. There's a second child. I'll see you in December on the second child.
okay. So should they have expected that father would at least have transitioned to a non-filthy home?
Absolutely.
Okay.
But till you
But
come
that
in and you
didn't-
say, you know what? Forget this place. This should be condemned. Get the health department here. Get them out of here. But instead, they just keep going there saying, how come it's not cleaned up? And they call their friends come in and say, it was a little better this time. I mean, the DSS and the court, I mean, these are, think about the 6-month permanency plan hearings. You come and say, hey, you know what, Mr. Newmar, you're not making any progress here. Your house is still a wreck. You know what? Get out of that place. What, do you need help? Do you need rental assistance? He didn't have anything. No financial assistance of any kind. I assume he's getting medicated and that's it. He's a limited guy. She's a limited woman. These are our families. We see this all the time. So come in.
Counsel, I hate to
Thank
interrupt
you.
but you don't talk about the fact that he threatened the DSS workers on several occasions, nor the fact that he didn't consistently exercise his visitation rights.
Yeah, I did mention that, Judge, but let me address that more specifically. He did. He said some terrible things to the caseworkers. So what do you do then? You say, all right, this guy, he's a nut. Call his mental health therapist. They didn't do that. Is he on medication? They don't know. What's his psychiatric evaluation say? I don't know. We don't have it. You know, instead to say, you know what, go away. He's never going to get better. I'm not saying he would have been able to get this child back. I'm saying the threshold issue is not his threats. It's not the condition of his house. The threshold matter is, did they put together a plan that was detailed, was it molded to their circumstances? And it's not a formula. I was on vacation this summer up in Canada. Things went to hell. We changed our plans. We came home. You don't just keep doing the same thing and drive it into the ground. They did the same thing for 3 years and they said, you know what? You're done. There was no interaction. There was no effort. There was never any chance for this family.
All right. Mr. Raleigh, thank you very much.
Thank you.
Mr. Burkhardt, you're by video.
Can't hear you.
You're still on mute. There you go.
Now, Your Honors.
A little louder would be great if you can adjust it, but that's fine.
Okay, I'll do my best to speak up.
Perfect.
Usually I'm accused of being too loud, but I'll try to speak up now. So I appreciate the advocacy of my esteemed colleague, and I am very empathetic to what his client is going through. But the fact of the matter in this particular case is no matter how long we wait and how many services are put in place, the appellant is not going to be able to safely parent my client. So my position is there's a reason why the standard in this country and around the world has been the best interest of the child. Mr. Raleigh's argument verges on saying the best interest of the parent. And when we're going towards the best interest of the parent, that has consequences for my client. In this particular,
Mr. Burkett, you're the AFC, right?
yes, I am.
And are you asking us to affirm?
I absolutely am asking for you to affirm the lower decision of the court. Yes, Your Honor.
And as I understand it, the sole issue raised by appellant is that DSS failed to engage in diligent efforts. Do you disagree with that argument?
I definitely disagree with that argument. I believe that under the case law of this court, for example, matter of Gemma 2025, the department tailored their services towards the appellant's challenges. And on the other hand, the appellant never lived up to his obligations to show responsibility and initiative. The department offered mental health services. There was irregular attendance on the part of the appellant, and that was the main issue. And then on top of the irregular attendance, he never displayed in his parenting of my client that he had learned anything in the mental health classes. He was offered domestic violence classes as part of the mental health treatment, and he refused, saying there's no problem, despite the constant arguing between him and his wife, despite his violent threats, his uncontrollable temper. He was offered a parent aid, and he didn't really seriously, he attended the appointments, but never seriously engaged with the materials. The prime example is the fact that there were 42 assignments, and he completed 5 of those 42 assignments, and then his testimony was completely incredulous because he stated, well, I did all the assignments, I just lost all of those. Finally, with regard to the clinical visitation, he only attended about 50% of his visits, and of those, he was late for 40% of those. So he never got to the point of unsupervised visitation. He never showed enough that he was putting into place all these services so he could safely parent my client. And I would like to make one point. So I believe that not only did the department meet the standards for diligent efforts, not perfect efforts like my esteemed colleague claims is necessary, but diligent efforts, and I would argue even diligent efforts plus, because despite with what Attorney Rowley stated, I believe there was a lot of accommodation on the part of the department. And I'd like to just end on 2 specific examples. One have to do with the parent aid. The parent aid, first of all, was giving very concrete examples and everything. And we had the parents reflect back to see what they learned. And if they didn't learn it, then continued on to follow up. And in fact, she ended up going from the usual 3 to 6 months, which is offered for the parenting aid classes, up to 18 months instead. So I believe there were a lot of accommodations with respect to that. And I think,
Mr. Burkhardt, we'll make sure we know the record very well. So anything else you want to say kind of in winding up?
yes, I just like to make one more point in this diligent efforts. Plus, I think they understood very well the mental health disabilities that the appellant had. And I think the prime example is when the appellant stated that he was going to blow up the church and he was going to kill the caseworker and he was going to kill the foster mother, who, by the way, has the care of not only my client, but the sibling. They didn't call the police. They didn't permanently ban him from these parenting classes. They suspended him temporarily and then continued to work with them. Whether that was wise or not, I don't know, but they certainly were trying to accommodate him to the best of their ability, Your Honors.
Okay, we appreciate.
I just have one more question.
Absolutely.
You mentioned that the child is in the foster home with his sibling. Is that a pre-adoptive home? Is that what the future is going to look like? Should this go forward?
Yes, it is. The foster mother has had plans to adopt both of the children, and then all these procedures has been delaying that, which is why I believe my client is suffering. It's been 5 years. It's time to have permanency through the adoption of the foster mother.
Thank
Great.
you.
Counsel, again, my apologies for not getting to your case with the calendar, and thank you very much for your arguments.
Thank you, Your Honors. Appreciate it.
Number 792, Hogan and Willig versus Swarmville Fire Company.
Good morning, Your Honor.
Mr. Yankonis, good morning, sir.
Judge, this is an appeal from a ruling on a summary judgment motion, which dismissed my client's claim for attorney's fees relating to construction litigation that went over a long period of time, eventually got settled by another law firm. The counterclaims in the case are scheduled for trial next month, November 17th. Now, Judge Carvaccio had this case, and we'll have this case at trial. On August 20, 2024, the judge granted the motion focused on a very emotional meeting, which was attended by my client with the Swarmville Fire Department. According to the judge, my client terminated the relationship then and there without just cause. And I think, Judge, that important case law has been violated. I hate to use that word, but I guess I had to say that in this case with respect to the judge's ruling. Number one, Klein versus Eubank is a court of appeals case that says when there's mutual consent in the termination of the relationship, the attorneys keep their lien.
And you want us to look at the record, including that deposition testimony. I think of Mr. I'm going to mispronounce her, Ulasher, or whatever it is. You want us to look at that testimony and conclude that at a minimum, there's a question of fact as to mutual consent. That's your argument.
Yes, that's it. It's a kind of overly simplified view of it. I'd like to just, if I could, focus on the Cosme case, because I think it's an important Second Department case. Cosme deals with deposition testimony, where the court says, where there is equivocal, self-contradictory testimony, you can't read precision into the testimony that's not really there. Now, I questioned the witness, Mr. Colliker, about a letter. It concluded with the sentence, "We think it's in the best interest to terminate our relationship." Judge Colliker said, or Judge Kolovaki said, "Well, that's just being civil." Well, maybe so, but so the witness was questioned about the letter. Was asked, "Does this mean the termination was mutual?" His answer was, "It was mutual. It was a mutual understanding." He also said, "I would say the board approved quitting him on this date." But in the same series of questions, he testified, "I would say yes, it would be mutual because Corey quit. When the guy quits, you don't want to do business with him anymore," which underscores the point in Cosme. It's testimony and also in Friends of Thayer Lake. It's contradictory, confusing, equivocal testimony that leads to more than one conclusion. The judge found precision in it that's not there. Now, the judge said, "There's nothing in that testimony. This is just mutuality. The only way to reach that conclusion is to make a subjective choice about conflicting testimony," which is, I believe, what happened here. It's imparting, just like the court said in Cosme, you can't do this. You can't impart precision that's not there. It's not there.
But counsel, when you say testimony, are you talking about the transcript of the meeting, or are you talking about something?
I'm talking about Gallagher's testimony. We'll get to the transcript of the meeting, but because I'm going to get to my alternative argument, Judge, which is just cause. Now, Justice
There's a question
Kolovaki,
about whether or not that's preserved, because the first time you raised it wasn't your reply paper.
that's the argument, I understand. I mean, Judge Kolovaki did consider whether there was just cause. I can't say I argued it.
You know that typically we don't consider things in reply. You know, you've addressed that in your brief. You've made your arguments. We'll take a look at it.
Okay.
The question is whether it's a mixed question of law of fact as argued by your opposition, or whether it's solely a question of law, and whether or not it's fair. I mean, you've been in cases where the other side maybe raised something new in reply, and you would say that's not fair. We will look at that.
Can I make one last point, Judge?
Of course.
One last point. as to whether or not it's an issue of law or some mixed issue of law. In fact, if we had a contract case here, consideration is a legal issue. It always involves some kind of contradiction in the facts, but it's still a legal issue. And I submit that just cause is a legal question. It can be considered by the court, and I think it should be considered by the court, given the testimony, in the record showing that there were real problems with these clients. Corey Hogan testified that the relationship was poisoned, couldn't exist anymore. But I think that court should consider the just cause argument. Thank you for your patience,
Thank
Judge.
you. No, thank you. Mr. Roberts.
Good morning. May it please the court, Charlie Roberts from Gross Schumann for the Swarmville Fire Company. August 31st, 2015, Corey Hogan, in a profanity-laden outburst, says, "We're done. Go get another law firm. I'm not taking this bullshit from you anymore." And excuse the language. There's a recording of the meeting for the court to listen to. That is the moment they quit. Now, procedurally, law of the case was not raised until the reply brief on this appeal. In the law of the case argument, that some comment that Judge Nowak made during oral argument, somehow law of the case 6 years later after depositions and discovery has no merit. It's completely improper. The just cause case argument, Your Honor, wasn't raised below. It was attempted by way of an improper reply that was never e-filed and left on the podium for, I guess, that service. But it was never raised. And then they attempted to argue that this improper reply should get in the record, and Justice Koliakovo specifically rejected it. So I don't think the court should consider either of those two arguments. Now, on the question of fact issue as to whether we're done, go get a good law firm, if that's not enough. At his testimony, Corey Hogan says, "I certainly told them," this is his deposition testimony in this case, "I certainly told them that we could not continue to represent them." He admitted he got upset and said, "We're not going to continue as your lawyers." These are Corey Hogan's own words. Why did he do this? His words from the meeting on August 31st. "You think this is ever going to be a winner for us? We're getting stiffed a big chunk of our fee, and it's coming out of my pocket. I'm the one that's going to eat 100 grand, and I'm supposed to feel bad for taxpayers." Word for word, those are Corey Hogan's words, and the court can listen to it itself if you haven't already. And the Suffolk Railroad case, if your fee becomes unprofitable, that is not cause. The idea that this was mutual is a fiction. It's fanciful. And it also doesn't matter for summary judgment here. They rely on the Cosby case. That was testimony of a former employee about the location of this. That was the quote unquote sole evidence in that case, was that testimony. That is a far cry from this case. The overwhelming evidence in this case shows that it wasn't mutual. But a key point that I want to make is that the point of mutuality isn't material. It's the moment the lawyer quits that matters. And in the Eisenberg case discussed in our brief, the moment the attorney demands the client get a new attorney, the case is abandoned. That happened on August 31st, 2015. We're done. Go get a good law firm. They talked about they like to talk about these letters, and this epitomizes the case. So they talk about a comment at the end of the letter, and this is page 1342 in the record. "The Swarmville Fire Company Board of Directors agrees it's in the best interest for our company and Hogan willing to complete the termination of the relationship so the parties may move on." But they ignore the rest of the letter, including the sentence that Judge Koliakovo correctly pointed out. "Attorney Corey Hogan made the unilateral decision on 31 August 15 to withdraw as Swarmville Fire Company's legal representative." So you can't read one sentence at the end. The letter that the fire company sent 8 days later. "SFC, the volunteer fire company, is surprised and dismayed with your 8/31/2015 decision to unilaterally withdraw from the ongoing case which you are representing Swarmville Fire Company against K2M Architects and Pacone Construction. Let there be no mistake. SFC is not in agreement with Hogan Willig's decision to abandon SFC's case without reasonable justification." Mr. Golliker's testimony, 77 years old at the time. There were objections during that testimony. It was clear They were trying to take advantage of this man. I would say yes, it would be mutual because Corey quit. It was not mutual. They quit. They told us to get another lawyer. If this isn't quitting without justification, I don't know what is. It's absolutely what it is. The fact is, Corey Hogan knew exactly what he was doing when he quit, and he knows what he's doing now. He's continuing to play games with the fire company. His whole premise here is to punish them for not just giving in and paying at the beginning when he demanded extra fees after being paid $250,000 in hourly fees. And they're doing it right up till yesterday when Judge Koliakvo denied their motion to stay the trial.
You're asking us to affirm.
Yes, sir. Thank you.
Thank you. Next case for argument is number 793. Boyd Trin versus Father Joseph. Nike.
Good morning, Your Honors. May it please the court.
Good morning. Give us just 1 second while everybody gets situated.
Sorry.
No. You've waited your turn. We're going to give you an opportunity. Just need an extra second.
Thank you, Your Honor.
We're all set, sir. Go right ahead.
My name is Hong Ta from HGT Law. I'm here on behalf of the appellant. Your Honors, I'd like to divide my argument into 2 parts, keep them very high level. The first part to address the trial court's application of the anti-SLAPP statute and its actual malice requirement, and the second part to discuss the trial court's consideration of the alternative grounds where the trial court dismissed for failure to state a claim under 3211A7. With respect to the first part, the application of the anti-SLAPP statute, the trial court made 2 fundamental errors. The first error was that the trial court disregarded two Fourth Department orders and contravened the well-established principle in New York that when an appellate court issues a decision and remits to a trial court for further proceedings, the trial court is supposed to conform strictly with the mandate of the appellate court upon remitted to her. And here the trial court did not do that. The second error.
So let's say that that's true, and I think it probably is true that they went a little further than we asked them to. They ignored the fact that we resolved the question. Okay, so then what happens with that? You know, they did then go to the second part, and I think that's probably where we should focus our efforts on. You know, if they overstep their remand, their mandate on remand, then what are the issues that remain, disregarding the law that they applied?
Sure. Let me turn to that then. What the trial court did was the trial court looked at 20 sets of defamatory statements, Your Honors, 20 sets of defamatory statements, and held that they were non-actionable, every single one of them. I would make 3 points with respect to that. Or two points, actually. The first point was the fact that we've got 20 different sets of statements, and what the trial court did was found them to be hyperbole, found them to be epithets, found them to be non-actionable opinion, every one of the 20 sets of statements. What the trial court did was it referred to the pleading standards, the well-established pleading standards in New York, but then didn't apply the pleading standards. For example, at the record on page 69, paragraph 3, the trial court actually states this, that the statements are not false. That's not the standard or review on a motion to dismiss. That's a finding of fact. The statements are not false. And what the trial court did was ignore the liberal notice pleading standard in New York. It didn't give draw inferences in favor of the plaintiff. It didn't assess whether the claims fit within a cognizable legal theory. And there was argument early in this courtroom about that. That's the standard. And here the trial court went beyond the standard of review that's applicable on a motion to dismiss under 32A7.
So it's my understanding then, sir, that you would like us to go through each of those 20 statements that, you know, have been selected and examine them on our own to determine whether or not they, give rise to a claim.
Yes, Your Honor, but I can assist you in that respect. To put those 20 statements in context, this is not a situation where the defendant made 1 or 2 statements in the heat of the moment in the internet, Facebook, whatever. These statements occurred over a year and a half. There were 20 sets of statements between May of 2019 and September of 2020, a year and a half worth of statements. And in those statements, he accused my client, Mr. Hoi Trin, of criminality, immigration fraud, called him a terrorist, called him a scammer, called him a fraudster, repeatedly made these statements in connection with his work.
So you're saying we should consider the cumulative effect of those statements over time?
Yes, Your Honor, definitely, because we have to look at the context of the statements. We have to look at the tone. We have to look at the purpose. That's what the decisions of this court and the Court of Appeals say. And we have to keep in mind what he was saying in his statements. The defendant was not making statements of opinion about his views, his personal views. He was accusing Mr. Hoi Trin of something very specific. He was saying that in the context of an immigration program that was implemented by Canada in 2012, under a memorandum of understanding, he was saying that Mr. Trin was substituting people who were on that program, who were eligible for that program, removing them and replacing them with non-eligible people who were either wealthy people or who were ineligible in some other way, right? So he was making a statement of fact. He wasn't expressing opinion. He was saying that Mr. Trin was replacing them, and because of that, he was engaging in human trafficking, he was a terrorist, and that he was committing immigration fraud, none of which has been proven or established or even investigated by anyone, right? And Mr. Hoi Trin was engaging as part of his organization, Voice, in the assistance of stateless refugees in Thailand. And most importantly, Your Honor, I think this is the other point about the statements. Defendant told his audience that his statements were statements of fact. Because he said, and this is in the record, he said, the things that I said had been verified and I am fully responsible for them. He's verifying, he's telling his audience that these are statements of fact and not of opinion. So I think you have to look at all these statements in context, and I don't think the trial court gave us sufficient deference on a motion to dismiss. The plaintiff sufficient deference. I know Your Honors want me to address the alternative grounds, but can I just make one quick point about the first part, the anti-SLAPP statute? The failure of the trial court, or the trial court's reconsideration of the anti-SLAPP statute has grave consequences for my client here. Under the one motion rule, the defendant had one shot at making an anti-SLAPP motion to dismiss, right? We survived it. There's a cost shifting, an attorney's fee shifting provision under the anti-SLAPP statute. We survived it the first time. And now essentially the trial court permitted the defendant to make the arguments again, essentially making a second motion in contravention of the one motion rule under 3211E. And that in effect subjected our client to double jeopardy, to put it colloquially, in terms of attorney's fees. And those are our submissions, Your Honor.
Thank you very much.
Thank you.
Good morning, Your Honors. Still morning.
Still morning. All set.
May it please the court, Kareem Abdullah from Finnerty Ostreicher and Abdullah on behalf of the defendant respondent, Father Nguyen. I appreciate the court is very familiar with the record in this case. I would try and focus.
Let's start right away.
Okay.
All right. So the first question I asked your counsel without letting him get too comfortable was, whether or not the court overstepped its mandate on the remand. And he said yes. What's your answer?
My answer is unequivocally no. And I think that that's clear from the record. And this actually ties into one word that my esteemed colleague brought up repeatedly, which I think is really a good theme for this entire case and this entire argument, which is context. Context is a core principle of defamation law, and it permeates every aspect of this case, including the remand itself. Contextually, when this case was first heard, and decided by Judge Sywek in the fall of 2021, all the courts that had examined the issue as to whether or not the amended anti-SLAPP statute applied to cases that were commenced before but continued after the effective date of the statute, had examined it one way, and that was the retroactivity analysis. Okay, and all the courts at that point in time had concluded that the legislative intent was for the amended statute to apply retroactively. That was the context of Judge Sywek's first decision. The case comes up to this court in 2022 on the appeal, and in that intervening time, the first department in the spring of 2022 decided Gottwald won. And in Gottwald 1, the first department said, no, we've looked at the legislative history, the legislative intent, and we don't find there's sufficient enough information or evidence to overcome the presumption against retroactive application. That was now new context. That was the context of this court's decision in December of 2022, where you followed the first department and said the appellate divisions have now spoken on this issue. It's not retroactive. Okay, so now we fast forward then to the spring of 2023. The spring of 2023, the parties, my firm was involved at the time, but the parties applied for a stay in front of Judge Sywek. Okay, after Your Honors had remanded it, they applied for a stay specifically because they knew Gottwald was going up to the Court of Appeals. And they specifically, in that stay, it's part of the record, page 290 on the record, said the Court of Appeals decision in Gottwald would, quote, directly impact the disposition of the instant case. Okay? As we all know, the Court of Appeals in Gottwald in the June of 2023 then looked at the question, and I believe it was Justice Garcia scratched his head and he said, why are we even talking about retroactivity here? Because the statutory language speaks of commenced or continued. And the court focused its analysis on the issue of whether or not the application of the amended statute to cases that were continued after the effective date implicated the same due process concerns that a retroactive application would. And the court concluded it didn't. And so therefore we could apply the amended definition of a SLAPP and also the fee provision to cases that were commenced before but continued after. That's what the Court of Appeals held in Gottwald, and it reversed the first department. After that, we had the first department decide Reeves, where it applied both the expanded definition and the attorney's fee provision. Your Honors, in June of 2024, heard and decided the Sweezy case, where, again, that was a case that was commenced before, it was commenced in 2017, but continued after. Your Honors recognized that although the case would not have fit the definition of a SLAPP case at the time it was filed, under Reeves and under the Court of Appeals decision in Gottwald, it now applied. So, getting back to that was the context then of Judge Sywek's second decision. The argument has been made that Judge Sywek ignored a mandate of this court. I don't think the judge did. Okay, Your Honors decided that the amended statute could not be retroactively applied. Judge Sywek didn't do that. Judge Sywek in her decision said, retroactive application we're not dealing with. We're talking about the or continued part. The Court of Appeals makes it very clear that there's a difference between retroactive application versus prospective application. The appellant in this case argues there is no difference. Okay, well, we think the law is very, very, very clear on that issue. There is a difference. Judge Sywek decided it on the or continued basis. For that reason, she felt, I think correctly, that the anti-SLAPP statute does apply to this case. Therefore, the actual malice standard applies. And she
Let me get to it.
Yes.
For me, anyways. Do you agree that Supreme Court exceeded the scope of our remittal in a technical way?
I think that argument can be made, but I don't think she did, because I think the remittal in your decision, with all due respect, if I'm misreading it, your order, your memorandum and order said you cannot the statute can't be applied retroactively. And that was, remember, the sole basis for her initial decision. So because of that, we have to reverse you on that ground. Now, Judge Sywick, you didn't decide the alternative grounds for dismissal, so we want you to go back and decide those alternative grounds and decide the motion anew. So the matter goes back to Judge Sywick with both parties understanding and stipulating that Gottwald was going to impact the decision. The decision, the Gottwald case gets decided by the Court of Appeals, and all of a sudden, the appellants are saying, well, we don't want you to consider that.
No, I'm not sure you've answered my question with all respect.
I think
we had a very specific remittal direction.
And I think the court followed that. The court did decide the alternative grounds. And I think the court also looked at the case within the structure of the law at the time, which is Gottwald and Reeves and this court's decision in Sweezy. So I don't think that this court violated anything of your decision. I think the court, I think she did what she was told to do. She did something else in addition, but this isn't a case like I think one of the cases cited in appellant's brief where Your Honors in, I think it was page 15, Your Honors had decided and held that in that particular case that they cited, that arbitration should be stayed pending a decision as to whether an insurance coverage issue. And you sent it back to the trial court. And the trial court said, we're going to let it go to arbitration anyhow. That's a clear case where you have a trial court that's exceeding its mandate and it's doing something that is completely improper and illegal. And in those cases, absolutely the court should be chided.
And I have to say, you're getting a little short on your time.
Okay.
And I think you need to let us know, at least from my part, do you think that Supreme Court got it right on a 3211A7 issues in every instance? That is, do you think that Supreme Court was correct as to each of its grounds for each of the alleged defamatory statements?
Yes, I do. And the reason again goes back to the issue of context. Okay, that's the important thing here. Here we are talking about statements that weren't made in English. We were talking about statements that were made in Vietnamese on social media pages. Now, the courts have told us, as we've already highlighted in our briefs, that statements that are made in the context of social media presentations are treated differently than hard news. And rhetoric and vigorous argument is
you suggested alternative basis to affirm as to each of the statements, or do you stick by the sole basis for each of the reasons that Supreme Court found that the defamatory statements were dismissible?
I think the court in
your brief, did you set forth, here's my ultimate question, I don't think I said it very well. Do you say that there are alternative bases to affirm? That is, Supreme Court might have got this wrong on the basis for dismissing this defamatory statement? Or do you strictly say in each instance, Supreme Court got it right?
I believe that in each instance, the Supreme Court did get it correct. Some of the statements were not of and concerning the appellant. Some of the statements were clearly opinions. Some were substantially true.
So I could write down that you say that we need to evaluate whether or not Supreme Court got it right as to each defamatory statement and not look for an alternative basis to affirm.
I think this court can do either, but I think
I'm asking what you've argued is what I'm not being clear about apparently.
I think we argued that Supreme Court got it correct and the Supreme Court's decision should be affirmed.
That's what I thought. Okay.
Yes. And the final point that I think needs to be made here is, again, going back to context. There have been allegations that my client has said things like terrorism and human trafficking. Again, when the statements are reviewed in their context and in their entirety, it goes to show, A, we're talking about a limited knowledgeable audience, but B, for example, one of the co-founders of Voice, this is a matter of public record, okay? He's also the executive director of the Viet Thanh. Now, the Viet Thanh is a US-based entity which the US government likes. The Viet Thanh is also an agency which the government of Vietnam considers to be.
I think we're ready for you to wrap up, Counselor. Anything further in conclusion?
We believe that Judge Sywick got it right. We believe that she was right in every respect, and her decision should be affirmed in its entirety.
Thank you for your argument. Moving next to 794. This is Turner versus Burros. Ms. Eminger, Mr. Collins, it's still good morning to you both.
Good morning.
Ready for your arguments. Go right ahead.
May it please the court, Rachel Eminger for the appellant Jim Voros. He's the owner of property at 67 Fuller Street in Buffalo, New York, where this incident occurred. The plaintiff, Sharon Turner, fell off a back landing, which was the main entrance and exit for the home. We're asking that the court reverse the lower court's denial of our summary judgment motion. First, I just want to touch.
I'm going to get right into it for Mike, and then you can continue on with whatever you think you need to say, Ms. Eminger. But it seems to me that one of the arguments that's floating out there is that your expert only testified as to an opinion regarding compliance with codes, as opposed to more generally as to whether or not this was a hazardous or dangerous condition. Do you agree with that?
I disagree with that, Your Honor. Our expert, Mr. Pearl, what he does is he notes in the bill of particulars that there was no specific allegation as to what exact standard or code violation was violated. What he does then is goes through all of the allegations in the bill of particulars, and he goes out and he finds what has jurisdiction over those common law terms that are alleged in the bill of particulars. And what he does then is explain that the Uniform Code has jurisdiction over these standards, or excuse me, over the general allegations in the BOP. He explains that the New York State legislator, the Division of Building Codes, that they are the ones that dictate and administer what the standards are, the building standards are.
Okay.
You first.
Okay, well, my question has to do with what Judge Kern.
Okay, I do want to finish Your Honor's question.
About generally speaking, does your expert say that this is a reasonably safe place, but then again, you answered that question with codes and standards. Okay, so that's my question is, they say that it's not a reasonably safe porch, okay? And they point particularly to the fact that it used to have a railing, and there's evidence that there was a railing, and it's not there anymore. And sort of the proof is in the pudding. She fell off because there was a guard would have kept her there. I have it right here because I wanted to see exactly what your expert did testify to, and I got codes and this and that, and I got no address of that issue that plaintiff's counsel raised, which is it was unreasonably safe. And one of the reasons it was unreasonably unsafe was that there was a railing there that had never been replaced. And your expert never discusses that. It's not, unless I missed it by trying to read too fast.
So I do want to address all of those points. There was a lot of different things in there, and I do want to address each and every.
Start the first with Judge Kern's actual question to you was, what besides, the codes did your person address?
So when I talk about the code, the Uniform Code, what that does is it dictates and administers the standards as well. So our expert, in looking at the allegations, is required to go out and find what is the source of this, what is the authority on this. And what he does is he looks at those standards that are dictated by the New York State legislator that is mandated. So I think there is an overlap between the code and the standards for what the stairway should be. And he's required to find an authority. And plaintiff, in response, is entitled to come back and say, no, this isn't the authority. But I think him looking to that authority through the building code, through the legislator, he's entitled to rely on that. I think that at the very least meets the defendant's burden. And I will say, Mr. Pearl, that that isn't just it, right? He goes out and he inspects the stairway. He does provide the opinion in his affidavit that the stairway is not a fall hazard, it's not defective, it's not deteriorated, it's not unsafe, and he's using those words and standards as they are in plaintiff's verified bill of particulars and as they are discussed by a legislator in the code. And I think that's sufficient. And one thing on that, just in terms of the defendant's, well, two more things on that, on the defendant's burden is, one, that's not the only thing that was submitted, right? So I think defense burden is actually bolstered by the fact that we do submit the housing authority inspection, perhaps maybe not in and of itself, if that was the only thing we submitted, but it does bolster what we've already submitted, as well as the fact that for 30 years, 20 of which the plaintiff herself has used this property in and out, the main entrance, absolutely no issues, no incidents, no falls, no complaints whatsoever.
Let me stop you for a second, but wasn't this particular incident a little different than every other one? In fact, that there was something blocking her egress, let's call it. Well, you know, that I don't know if that had ever been the situation in the past. And so now if she's in a tight space, okay, because something's blocking her going the other way and she falls off the side of the landing. Doesn't that make this situation just a little different?
No, Your Honor, respectfully, I don't think it does. And part of that is because the case law is clear and we're dealing with an absence of railing. And I think that actually also goes to the initial questions that both Your Honor and Justice Kern has had about the hazard of the stairway in general. And I think it's really, really important to note in this matter that this record is absolutely devoid of any other defect, dangerous condition other than the railing itself. Respondent's brief explicitly says that. We're only dealing with the absence of a railing. They specifically say that defendant's liability does not hinge on any premises defect that precipitated the fall. They're only talking about the railing, as well as their expert as well. So plaintiff's expert goes out, looks at the stairway.
Yes, Counselor, if I may, my understanding that the problem with the lack of the railing is also that you need the railing to lean against or to keep you on that top step because it's so small. When that door opens up, there's no room to maneuver in there without the railing. It's the railing coupled with the design of the step itself.
2 points on that. First, the door had absolutely nothing to do with this incident.
Well, we have the photograph, right? It shows the door opens right.
She had exited, she was asked this in her deposition, it's clear in her deposition, she had exited the landing. The door shuts behind her. She admits no issue with the door, no issue being on the railing whatsoever. The door doesn't play any issue. And perhaps plaintiff may have been able to create an issue of fact with respect to design if they so choose, but their expert went out and found absolutely nothing wrong with the design. Found nothing wrong with the stairwell itself, found nothing wrong with the size of the stairwell. Doesn't even measure the stairway. He describes it as a small concrete landing. I think saying, a passing description, he's not saying that there's anything problematic with the size. He doesn't even measure it. He doesn't compare it to, I guess, what he would consider a standard size. We don't know because there's no issue with that. I think the record is completely devoid of any other issue with the stairwell except for the attempt to create an issue of fact as to the lack of railing. And I think what's significant about that is because I think this issue has been litigated repeatedly as to the railing issue. And I think it does take us outside of maybe a fall case in and of itself because it has been so deeply litigated. And what we see is the case law as well as this court in Westermeyer in 2023 said, okay, where you have code compliance with the railing and no other defect or dangerous condition, summary judgment on liability is appropriate.
And I have Westermeyer in my hand here, and it's an and. It gives two things that you have to do to meet your burden. And I'll read it. They met their initial burden by submitting evidence establishing that there was no dangerous or defective condition existing on the property at the location where plaintiff fell, and that the stoop was in compliance with the applicable codes. And I think you've done like a superior job in showing us the second part of that, the compliance with the applicable codes. But I take a little umbrance at the fact that there was a railing and it is missing, okay? And your expert does not discuss that at all, you know, about the effect of that being missing and making it less safe or unsafe.
And the reason for that is because the railing isn't required to be there in the first place pursuant to the code and standards. And Westermeyer actually discusses that as well. So in that case, the homeowners had a railing on their porch, very, very similar to what we're dealing with in this case. They actually had a railing on there and they affirmatively took the steps to remove the railing shortly before the incident in that case occurred. And the court, again, in that case, this court said that that's not dispositive because the railing's not required to be there in the first place. And I think, so this court has said that I believe all the other departments, and I submitted a lot of case law on that issue.
Talking maybe about the difference between required, like per statute, per the codes, and the safety and the general safetiness of an unguarded stoop, you know, it outside of the statute or outside of the codes.
So what I think is the main point with this case is what we are dealing with is the absence of the railing in and of itself. And the case law that was submitted by the plaintiff, and it is out there, is when the code compliant condition is part of or contributed to a general unsafe condition in the area, then perhaps that could be an issue of fact. But what this case deals with is just the railing in and of itself. So plaintiff, in her deposition, and actually in opposition to the motion, went ahead and submitted an affidavit, but included nothing further as to what a dangerous condition, what supposed dangerous condition was in the area. Mr. Lewis, their expert, went out and took a look at the stairway. And again, the sole thing that they are talking about is the absence of the railing. And the case law is clear as when that is the sole issue and that is compliant with the code, it's not actionable. So I do agree, absolutely, is if there was something more, and I believe it's the Rubin case that I cite in my papers from 2023, because the handrail was not required by the code, plaintiffs claim that no railing was available by itself is insufficient to show that the stairway was defective or dangerous. Because I think what that leads to then is it renders the findings of the New York State legislator and the code essentially moot, because they've already found that the railing, the absence of the railing, is not required, that is reasonably safe.
You rely, and I'm going back over similar territory, others have treaded here, but the Westermeyer case, I look back there at the record, and there was an expert for the defendant that said basically, it had the same code analogy as Justice Bannister pointed out, that certainly addressed the code. And the expert there said floor area is more than enough for most people to stand comfortably. He also averred that the porch was in good condition, was solid, firm, level, and was well maintained, and was reasonably safe for its intended use. Here we have your expert saying, my review of the subject exterior steps find that they met the requisite conditions of being structurally sound, good repair, properly anchored, and capable of supporting imposed loads. And then the overall thing that it's not a fall hazard or otherwise defective, deteriorated, unsafe, hazardous, and or unlawful condition. Would you agree, Ms. Eminger? It seems we have to compare the expert affidavit there for the defendant to here to determine whether you met your burden, thereby shifting the burden to the plaintiff.
Yes, with the understanding is I don't think any expert affidavit is going to be exactly the same, but I think in what you have relayed to me, I think Mr. Pearl's affidavit certainly fits under that. Like I said, he attaches the standards, he goes through each of them, he inspects the property, he shows what he relies on, and he comes to his conclusion. And that's only bolstered by the other evidence that was put in the records, the housing authority's inspection, which the stairwell passed, the over 30 years of use of this as the main entrance and exit with absolutely no issues, compounded by the fact that there is nothing in the record that there's any other hazardous, dangerous, defective, any other issue with the stairwell. I know on page 17 of plaintiff's respondent brief, they actually use as an example, a loose step. That's not their position, that there's anything wrong with the stairwell. Their sole issue is the absence of the stairwell. But we know that in and of itself is reasonably safe, as the code dictates.
You understand, Ms. Andrews, this is how I perceive it, and I'm not sure if the other panelists think the same way, or maybe this is not even the right thing, but I look at you as essentially moving for summary judgment on question 2 in the verdict sheet. Question 1 can be, if there's a dispute, did the condition even exist? But put that question 1 aside. And then this question 2 is typically, was that condition unreasonably safe? You're moving for summary judgment on that question. I know there's some argument about proximate cause, but when you look at our cases, when it comes to negligence, we would typically assume negligence when analyzing the proximate cause question, because you don't get to that question in the verdict sheet until you cover the previous one.
Sure.
So you really need to win here on question 2, as I call it. That is, that it's not an unreasonably safe condition. Is that a fair way to kind of summarize your argument that will need to come relatively soon to an end?
Yes, Your Honor. I do think that we should win on causation as well, and I can address that, but I would agree with you that I think our strongest point, and I really think that the case law is clear when it comes to railings, that absence of the railing in and of itself, without more, which we don't have in this case, warrants summary judgment in favor of my client. So I do think that's my the strongest argument. I will address causation if the court so chooses, but I'm happy to rely on my papers.
We're going to let you rely on your brief.
Thank you
so
Your
much.
Honors. Thank you, Your Honors.
Good afternoon, Your Honors.
Good afternoon, Mr. Collins. You probably have a pretty good sense of the questions and answers that we've heard, where we are in terms of our knowledge of the case. I think we're very familiar with it, and go right ahead.
Yes, I just want to lead with what I think is the deficiency in the expert affidavit of Kenneth Pearl submitted on behalf of the defendant, by means of which I think defendant failed to establish his prima facie entitlement to summary judgment from the get-go. Mr. Pearl's opinion was predicated, I think, almost entirely on the absence of building code provisions requiring railings or handrails on a landing or staircase such as we're dealing with here. But obviously, it's well established that compliance with statutes and building codes does not establish that a property is satisfied, that a property owner has satisfied his or her common law duty to maintain the property in a reasonably safe condition. And I think when you strip away all of Mr. Pearl's discussion of the what the code provides and how the code did not require any sort of railing here, what you're left with is opinions essentially stating, I'm an architect and I think this was safe. And I don't think that that is sufficient to carry the burden. And I think that distinguishes what the proof was in the Westermeyer case that the court already alluded to. But even assuming that defendant met his threshold burden of proof via the affidavit of an analysis by Mr. Pearl, who I note didn't even reference, as the court has already alluded to, the prior presence of a railing, didn't attach any photographs, discuss photographs of the building here and the outside landing. But assuming that that was sufficient nevertheless for the defendant to meet his burden, plaintiff raised a question of fact through the affidavit of his expert, Brian Lewis, who opined that in his professional opinion as an architect again, guardrails are critical aids in helping to provide for balance and fall protection, and that to a reasonable degree of architectural certainty, the landing was not reasonably safe given the absence of a railing. So if Mr. Pearl's affidavit is deemed sufficient to carry the defendant's threshold burden, then certainly the countervailing opinion by Mr. Lewis is sufficient to raise a question of fact because it results in
The opinion
essentially.
there by your expert, as I understand, Mr. Collins, to kind of sum up on it, was that the unguarded landing was not reasonably safe.
Correct.
He also said, and a guarded landing would have prevented the fall. I don't know how he could possibly get to that second statement when the plaintiff didn't know how she fell, but I'm not sure we ever get to causation. It sounds to me like we're at the focus on what I call that question 2 on the verdict sheet. Was it reasonably safe? And your expert has, no question said the unguarded landing was not reasonably safe. And on that basis, you would say you raised a triable question of fact if we find the defendant carried the burden. That's basically it.
That's correct. And I would just, if I could add 2 more things. One is I cite the case of Douglas F. versus Williamsville Central School District, where the court held that even in the absence of an expert opinion, a jury could, based upon photographic proof, conclude that a situation in a building is dangerous. And here I think the jury could, just looking at the picture that's at 4950 of the record, say, yes, there should have been a railing here, especially given the fact that there used to be one when it was built and there no longer was. And then finally, on the issue of proximate cause, I know the court doesn't really want to get there, but
I'm not sure that's true. That's just my part.
Okay.
But
the
go ahead.
plaintiff did testify. She was asked, did you try and stop yourself from falling? She said, I think I did because I broke my left wrist. And therefore, because I was standing, 8 inches away from the edge on the landing, I think I reached out to grab it. Otherwise, I wouldn't have had my wrist out. And therefore, I think the absence of a railing could, a trier effect, readily find constitute a proximate cause, because the jury could find that plaintiff would indeed have stopped herself from falling and the railing would have prevented her from hitting the ground.
Mr. Collins, thank you very much.
Thank you.
Okay, 795 is submitted, and then we go back to 796.
Yeah.
Madison versus State of New York. Am I missing one?
Yeah. 795. Respond.
95 is submitted.
Oh, that's right. I did get a note. Please come on up. I was fully informed, but this is not my day, apparently. Already.
No worries. All right. Good morning. May it please the court. Anna Sanderson on behalf of the defendant appellees. It's our position that this court should affirm the trial court's order compelling the authorizations of the plaintiffs on the grounds that the plaintiffs voluntarily and affirmatively placed their medical, both physical and mental, physical health conditions, as well as their economic and academic information at issue. And pending any questions from the court, we'll be resting on the arguments made in our briefs.
Again, my apologies, but thank you very much.
No problem. Thank you. Have a good day.
Now, 796. I got to bring Mr. Hitches back in. All right, Mr. Hitches, can you still hear us, sir?
I can still hear you. Can you still hear me?
We can. We're going to let Mr. Pajak make his argument on 796. Go right ahead, sir.
All right, good afternoon. Now, Your Honors, I feel like last night's dinner that's just been reheated in the microwave for lunch, never as good as it was the first time, but I'll try. We are here now on the motion to renew. So this little bit of deja vu here, but on the renewal motion, a lot of the same issues were addressed, but this time the claimants came forward with additional proof of at least possible ownership by the state of New York and involvement in the canal where this tragic accident happened. And again, the problem here is that the Court of Claims, at least being consistent, engaged in another hyper-technical analysis instead of the more liberal analysis of the proof before, just to see if there was potential merit to the claim going forward. In other words, and I was
up again against the discretionary standard.
We are.
And you know, we obviously know the case, as you figured out from the first argument. So for my question on my end here, I didn't see any argument in your brief, as comprehensive as it was otherwise, that there was any reasonable justification. I got to get the language of the cases.
For not having it produced in the first place.
For failure to submit those records in support of your earlier motion. You acknowledge that standard in your brief. I actually did the word search last night, but I saw no discussion of that issue as to why it was that that if your argument is ownership in any way, shape, or form, you couldn't have gone out and gotten deeds, gotten whatever you got later on,
right?
All of which was available beforehand, because the evidence of ownership in some form would have existed as at the time of the accident and would have been available. I'm letting it all hang out on that one as well, Mr. Pajak, but why didn't you address that, assuming you agreed you didn't address it? And if you did, what did you say about it?
I didn't address it specifically because I thought it was so obvious. This stuff was legal information in the ether. In other words, these were affidavits not from our case or even from, there was no discovery. These are affidavits from 2019, other matters. People got together after the initial decision where the Court of Claims denied it, and other plaintiffs' lawyers, frankly, started talking to other plaintiffs' lawyers, and people started saying, well, I have this and I have that. So the principle on a motion to renew is the availability, okay? I would submit that simply something in what I again call the legal ether does not mean it's, quote, available, because quite frankly, everything is available now at our fingertips. If you use your phone, you can Google or Grok or AI or ChatGPT, almost everything, but that doesn't mean it's really available to a particular claimant. And here, certainly the affidavit of Mr. Moreno in another case from 2019, and also Mr. Pump, his affidavit as well, not from this case, was not readily available to the claimants in this case. They did come to light subsequently, and quite again, frankly, they came to light because again, the standard employed by the Court of Claims was so stringent, and yet what ended up happening here is they got summarily rejected too. Not so much on the readily available argument. There was talk of that in the Court of Claims decision, of course, but again, what the court did was treat this effectively like a summary judgment motion, looking at whether or not certain things were admissible from a technical standpoint, including the maps, which again, under CPLR 4532B, should be presumptively admissible and considered by the court to see if there's potential merit. And again, I was thinking of Your Honor's question before in the earlier argument on this case, and I think what the analysis is supposed to be is there enough that this should proceed into discovery to flesh out whether or not the state has ownership here? Again, the state may be entitled to summary judgment at some point once discovery happens. But given the affidavit of Mr. Moreno, which was not at plaintiff's claimant's fingertips, the affidavit of Mr. Pup and the express opinions of Mr. Moreno and Mr. Pump, who are employees of the city of Lockport and engineers, where they state expressly the state owned the canal where this happened. Certainly that is enough to allow this claim to go forward, see what happens in discovery, and then if it turns out there's nothing, no meat on those bones, then they can move for summary judgment and the case gets dismissed. They're trying to do that now without any discovery on the part of the claimants. But clearly, between those affidavits, the permits that were issued to Hydraulic, which clearly indicate that part of the cave system was held back and still controlled by the state. At least that's my read of it. And then you have the court erring to failing to take a look at, from a lower standpoint, whether or not any of these items indicate that there's potential ownership or control on the part of the state. Again, this is at the very beginning of the case, and with that lower standard, the court should have granted renewal, and then upon renewal should have changed its decision, altered its decision, and allowed the case to proceed forward, because the totality of the evidence here is that there's more than sufficient evidence that there may be some merit to the claim here. Thank you.
Thank you. Mr. Hitchens.
Good afternoon, Your Honors. I'm going to start by focusing on the previously available component of a motion to renew. This is an important component when you consider the practicalities here. The claimants are alleging that the state was the owner slash operator. You would think that they would have something to back them up, but even more so, there was this motion to file a motion for late claim relief, which we opposed, and we submitted evidence that we didn't own anything. You would think that it would be incumbent on claimants to submit some evidence of ownership, and they didn't. As I said in the earlier argument, the Court of Claims notes that it's undisputed. And we have evidence, say what you want about the affidavits, but the affidavits are relying on GIS maps. That seems like a very logical starting point if you're trying to figure out who owns these parcels, and those are publicly available. The permits go back to 2012, 11 years before the accident. Those are publicly available. So for this reason alone, it was well within the Court of Claims discretion to deny the motion to renew. Now, if this somehow were excusable, the ground on which the Court of Claims primarily relied, which is that this evidence just didn't move the needle, was also well within the court's discretion. I think everybody acknowledges that the primary reason why this was denied was the lack of appearance of merit, and they're trying to support this theory that was unrefuted.
Counselor, let me stop you for one moment. Do you agree that on the motion to renew, though, the court was pretty clear that it did indeed rely on the submissions offered by the claimants?
Yes.
Yeah.
Yes, absolutely.
And that it does appear, though, however, that the court then compares that submission to the other submission and makes almost a factual determination here. And your position is that's within the court's discretion.
My argument is that what the court did was within its discretion, but I don't agree that the court made what is in essence a factual determination.
But just here's where it says that I'm on page 7 of the decision filed November 26, where the court says it finds it insufficient to create a question of fact after evaluating and comparing those challenged affidavits. Is that a discretionary question if the court finds an insufficient question of fact?
I think it falls within the rubric of abuse of discretion. Yes, Your Honor. And you're looking at it, does the record support it? I mean, ultimately it comes down to that. So you're doing a motion to renew, and you have sort of a double error here, because it's a motion to renew the denial of late claim relief. We take issue with claimants' seeming belief that they're entitled to proceed. They keep talking about this lower standard as though they cannot follow the rules.
That seems to me to be the first motion, but when we get to the second motion, these affidavits are in front of us.
Yes.
And so once the court accepts them, and then the question is, did the court abuse its discretion in doing this balancing test vis-a-vis the information within those affidavits? And did the court apply the appropriate standard in exercising its discretion on that? Isn't that really what's in front of us?
If I could make it quite simple, the question is whether you look at the affidavits and you find, is there something that really creates a question here with respect to ownership? And it was within the court's discretion to look at this evidence and find that it didn't. We had submitted information with the original opposition to the motion for late claim relief that was quite unequivocal. We had deeds divesting our remaining interest in the land. We had a map showing exactly where those are located. And we had a declaration explaining exactly what this does. We explained we did have an ownership interest, but we haven't since 2012. And in response to that, you have some affidavits, you have some maps, but notably absent from any of those is a single statement identifying New York State or the Canal Corporation as the owner of the Lockport Cave. The closest you get is the Moreno affidavit, which refers to the state as the owner of the canal system and its underground caves. But that's reconcilable because we know that since 2012, by virtue of the very sales that we were discussing, the Lockport Cave is not part of the canal system anymore. It was expressly abandoned, and we have those documents in the record. The remaining affirmations, as the Court of Claims finds, actually corroborate our showing in that they identify the Lockport Cave as being at 5 Gooding Street, and they identify the owner of 5 Gooding Street as Hydraulic Race Company, which is the private corporation that happens to be the grantee on the very deeds that we referenced in the earlier proceeding. The information in the permits, claimants try and conjure up ownership by reason of negative implication, but the only reason that the permits don't mention the Lockport Cave is because the permits address property rights on land that the state still owns, and the state doesn't own the Lockport Cave anymore. And certainly that's something that Hydraulic Race would be aware of because they had bought the Lockport Cave just a couple of months ago. And on top of all of this, you have a failure as a legal matter to establish what would the significance of this be. I know that claimants say, well, if the state has any kind of ownership interest, well, that means that this is a proprietary function. They could be held liable under the ordinary rules of negligence. But if you take everything that they say is true, give them every benefit of the doubt, what it sounds like we have is a situation where the state sold its interest in Lockport Cave to a private company and accidentally somehow still retains a couple of feet of the tunnel. And that, we contend, would mean at best the state is an out-of-possession landlord. And even under the traditional rules of negligence, if you have a situation where an owner doesn't understand that it's the owner and somebody else understands that it is the owner, you can't have liability absent either creation of the danger, and we know that the state didn't build the boat, the state didn't operate the boat, the flaws in the boat are what are being alleged as the negligence here, or alternatively, you would need some kind of contractual arrangement where the state would have assumed some kind of responsibility. But again, that's almost necessarily absent here because the state, as far as it sold off all of its interest in the cave.
Mr. Ish, I think we have your argument, sir.
Okay, that's fantastic, Your Honor. Thank you.
Great. Thank you for your time.